but we do need to pick up on the discussions that took place earlier. And I recognized 3 individuals prior to the break. It was Andy Chenner from Amnesty International. I think it was our colleague from the Ghanaian Human Rights Commission. And the third hand was Advocate Galeka. Can I start then with Advocate, if you permit? You okay coming up? Followed by Andy, followed then by Stephen, and then I do recognize Mr. Obilana, who wants to give an input as well. We are but tight on time, so if we could keep it as short as possible, that would be much appreciated. Thank you.
Thank you. I firstly want to address the question of how do we begin to change the mindset whilst we remain in the same environment. I think what is important for those of us who are already in the environment, we really need a lot of resources towards training, education, but we need to tighten our ethics policies. And we need to ensure that in executing our duties, we do them with integrity, because a lack of ethics starts really with how you execute your duties, but it also requires the top-down change management. And in particular, in institutions in which we work in Advocate Tipanyana, executing a legal duty can really not be an authoritative execution. It must be an execution that's based on the law and the facts at hand. Once it becomes an authoritative execution of duty, it really compromises the integrity. The fact that I'm senior doesn't mean that I'm always right when it comes to the law. And we really need to encourage open debate. And it's what I always say, even in the institution in which I'm in, is that if an investigator has done a report and the report is going through the protocols for quality assurance, the investigator needs to defend their report. It cannot be that I unilaterally decide to change a report because I feel so and I am the Deputy Public Protector, but it must be based on the facts and the law. And I need to transparently show that, you know, and our investigators need to be continuously, and that goes for public servants, continuously trained, but also encouraged to be confident about the work that they do and be able to defend that, because with a lack of that, you then find a lot of abuse of power, which you see across the organizations. I mean, I'm so I painstakingly stand here having listened to the whistleblowers and what you've gone through. And what pains me more is that even during this dispensation that is purporting to fight corruption, you are still being abused and nothing is being done. So I think, Advocate Tipanyana, what we need to do, particularly with Martha and Patricia, who are still in the system, and I think I heard you saying you've been assisting Patricia, is to see how can we assist them. As the institutions supporting democracy, I'm advised that amongst the Secretariat, there has been a discussion of how do we respond to the Zondo Commission report. And I think part of that, it's really seeking justice for those who have blown the whistle. Everybody else is worried about how do you turn around, how do you put the politicians in jail and everybody else who was involved, but nobody is speaking about those who blew the whistle and who are still suffering the consequences today. Thank you.
I have some notes, but don't be scared. It's not a speech or anything. It's just my memory's gone because of too much of psych meds. You know, mental health is a real issue. It's not a play thing or something in the style. So I just have a few notes so I don't forget what I want to say. That's all. I am Andy Chinner. I'm a human rights defender with, amongst other organizations, Amnesty International, and A couple of years ago, I was in a private discussion with Judge Albie Sachs, and he said, Andy, you're a bridge. And I said to him, what do you mean you're the bridge? And he said, well, you have lived through 24 years of apartheid and 24 years of democracy. You need to be the bridge between the two generations, as such. So I took that quite seriously and tried to understand what that meant. And as I listened today, I made a couple of notes on what I understood as the problems. One of the problems, and I don't know if you know the case with St. Andrew's College down in Makanda, where the headmaster has been finally fired because of a water polo coach that was abusing boys. In that case, I was actually asking, why does the loop end with the headmaster? Why can we not have a system which actually looks at the case using artificial intelligence, machine learning, actually pick out certain words in it and say, well, this is not only a case to be dealt by the headmaster where the loop currently ends, but it actually looks at the case and says, well, you need a social worker, you need SAPs, you need psychologists in here. Currently, I don't think that there's any system that does that. And that's what I also heard here today, is you may have what they call a single point of contact, but that single point of contact really is not, it's detrimental to reporting for whistleblowers. I like what we the people states. It states, amongst others, it's power of each of us to build a society steeped in human dignity, equality, and freedom for all. And as I look around the room, I see a lot of people that are in the legal fraternity, apart from our whistleblowers, which I'll say, viva whistleblowers, viva. And, I asked myself, if the SA Human Rights Commission needs to have resources, whether it be manpower or monetary resources, how are we as the people, going to help them to get the resources? Only through mobilization, or only through demanding that we protect the SARC, by demanding from government that they provide that funding and resources. And I'd like to pose that question to the organization, saying, how can I mobilize my colleagues and the rest of the people to actually help to get that funding? I think I like the phrase, Tumamina, send me, because I think a lot of people sitting here is saying, send me to fight the corruption in order to make a better South Africa. I think that's all I had to say. Thank you.
Stephen, do you still have a comment to make, Stephen? No. Or you saving it? Okay, you can. Just to announce, so we take that 2 comments. Nothing else from the floor. I'm holding a mic. So our next panel, which is the panel 3 discussion. Oh, my apologies, Mr. Obilana. Yes, Mr. Obilana, I do see your flashing hand. Safiso, be crossing over to the Mr. Obilana, if you could allow him to. Mr. Obilana, if I can appeal to you to please keep it short. We are running out of time very fast.
Thank you very much, man. Thank you, the program director. First of all, I want to appreciate the CEO once again for inviting me to this summit, to this platform. Indeed, it is an healing process. It is an healing process in the sense that when we listen to other victims who happens to be whistleblowers, we all know that we are having one thing in common, and that thing is that what we have in common is that we are all victims who are brutalized and who are killed by our superiors. But however, I will want to also say it would be nicer in case of next time if such people like us can be invited physically where we say our story. You know, it is very important so that people will hear the horrible and the pathetic story that we have. And perhaps maybe we will have some organization or individuals who will assist us, who will support us, especially while we are going through economical, financial, and even psychological problem which affect our health. Because we understand the mandate of the Chapter 9 institutions. You know, maybe their mandate is only for litigations and so on. But we need support, like somebody like me, my family who have been kicked out, have no source of income. Perhaps the CEO knows my problem very, very personally, in depth, what I'm going through and how we become an homeless person. But another thing I also want to say, it is very important as well that the institutions who need to support the whistleblowers need to clean themselves so that it will not be a case of reporting the corruptors to the corruptees. It is very, very important because many of us will rely on these institutions that they will assist us and they will be the one who wipe away our tears. But unfortunately, you might find out that some of the corruptors that you are reporting them to the corruptees who in other way support and to victimize us the more. So it is very important that they also look into themselves and clean themselves, because when we talk about the institutions, what make the institutions? It is the people who are there, who are working there, who make the institutions. The institution does not exist without people. And who are these people? Are they part of those who are colliding with the corruptors to kill the victims and to destroy the victims the more? And finally, I also want to find out, is it not possible that the Chapter 9 institution can also have a legislative framework whereby it would be that the employers, mostly the employers, especially in the public sectors, when they want to litigate, they use their own money instead of using taxpayers' money. They use their own personal money because when they use the taxpayers' money, they've got the muscles. They can spend millions, they can spend billions. Whereas we have nothing, we have no support. We are only spending our personal fund. For example, I went to bargaining council, I spent my personal fund, which I won the department, I was awarded, I won, and I know how what it cost me. And there we actually, even at that, it's not possible for Chapter 9 Institute to have a legislative framework to say any official that is designated in the public and by the employer, that they need to spend their own personal money for litigation. So that is another thing I just want to find out. And the question that people do ask me, that did I regret of doing this? I said no, I didn't regret of doing it. And if I have the opportunity again to report such crime, to report such corruption, to report such immorality, I will do it again and again. Even though I've lost everything that I work for, especially a vulnerable person, we all know South Africa, a vulnerable person like myself who happens to be a born South Africa. Even though my family, my wife is from South Africa, but it doesn't hold any water. We know, and we know the institution, we know some of the people who are there, what they did. So, but I said to somebody that I'm going to have a thing and or I'm going to have a book where I'm going to write my story, and they will see what is happening in our nation and what is happening in the African continent. Thank you very much. Thank you for the platform, because when I was sent the link this morning, I have to go to somewhere where I can have access to free Wi-Fi. I don't have money to buy data, but I'm able to use free Wi-Fi where I was, so that I can be able to contribute. We hope and we pray that God will spare our life, so that we can reap the fruit of the truth that we uphold. And those who are speaking lies, who are also corrupting and who are corrupting the corruptors, let them continue. God is going to start everybody's right. Thank you very much. God bless you.
Thank you so much, Mr. Obilan, and we do also acknowledge that you are connecting via a facility that has free Wi-Fi because of the current conditions you find yourself in. Just to indicate that it wasn't possible for us to invite all the whistleblowers to this event. There is quite a network, and we do respect their privacy. Some are not ready to speak out, to take the floor. Some are uncomfortable. So this is the start of an engagement, and those that have been following the work around the Commission on the issues of the strategic focal area, which is corruption and human rights, you would have seen a trajectory from last year, March, all the way through for the last year and a half, if not more, around our activities in this area. And naturally, whistleblower work forms part of that activity. So it's not the end of the conversation. It's merely the start of another part of the conversation. So there will be an opportunity for engagement, and hopefully at that platform we can call all the whistleblowers together and have a discussion about practical solutions to the issues that they face. Mr. Chenna, just to mention, you mentioned machine learning, artificial intelligence, etc. I know for many it might be new concepts, but the Commission is quite aware of that. We do have an area where we're looking at technology and human rights, and particularly the fourth industrial revolution. We recently released a book last year around human rights and 4IR, which I do encourage participants who are interested to access that. It is open source and it's available via HSRC, who co-authored with us. I am going to now move on to panel 3. I just wanted an indication from our colleagues from the Whistleblower International Network if they are logged in or not. There were some challenges, but in the meanwhile, I'm going to call on my colleagues from the Commission of Human Rights and Administrative Justice. It's also known as SHRAG, if that's correct, SHRAG, and they are based in Ghana. They are essentially the Human Rights Commission of Ghana. So our sister body and what we call in international parlance, the National Human Rights Institution, so the NHRI. They have a very unique setup where they have a component, like Mr. Obilan also mentioned earlier, around an administrative element. So the commission has that, where they have the justice part and the administrative part. And if I'm not mistaken, Stephen, you head up the unit relating to corruption and human rights, where whistleblowers is one of that components. And then my colleague Mary deals on, I think generally you head up the Human Rights Protection Division. If you are comfortable enough to please take a seat at the table. I keep wanting to say the stand at the table. And then, yeah, of course, I don't know who's speaking first between the two of you, but they will be giving some insight and reflections on the current international and legal or international legal and institutional framework. And of course, identifying challenges and gaps and issues around implementation, noting the unique setup in Ghana. Stephen, Mary, I'm not sure who has decided to. Thank you. And then, of course, I'll be in and out with the virtual platform as soon as we get confirmation from our colleagues on that side. Thanks. Stephen, you take that.
I didn't know whether I have to reduce my height.
Oh, wait, hold on. I don't know if is that okay?
Oh. Thank you very much. So, colleagues from the South African Human Rights Commission, colleagues from other human rights institutions, assuming that we were not here at the beginning of the program because we flew in from Ghana today. We toured down this morning. In spite of our tiredness, we're here. Indeed, when we came in, I asked Mary whether we would be able to, to sit through. But upon listening to the fiery speeches that were coming from some of you, at least some new energy came into us. So we are proud to be amongst you. And we bring you greetings from our commissioner, Mr. Joseph Whistleblowers, and our deputy commissioners as well. There's no time on our side, so I will just let you know what the structure of our presentation will look like. It will be in two parts. Mary would speak to you generally on the mandate of our commission, what the structure of the commission looks like, what it's supposed to do, what it cannot do, and how its accesses can access. So that perhaps there are some lessons that could be learned from that. We take it from there. Then thereafter, I will speak on the legal framework governing whistleblower protection in Ghana. And so this is what it is, our discussion is going to look like. We're hoping that at the end of it all, we will be able to meet the expectations of all of us. Thank you very much. So Mary, can you come in? Thank you.
Thank you very much, Stephen. I think now I can bring it down. Since all right, thank you very much. Colleagues from the Human Rights Fraternity and then from the Whistleblower company, let me put it that way. Madam Deputy Chair and Director, thank you very much for bringing us here. I think following listening to various panelists and then various speakers, I was actually telling myself that I guess Ghana, we have something good that is very important that we share with you. I think right from the Deputy Chair's statement, he kept mentioning ethics management. And when she came back here, she also mentioned it again. Rita also did indicate that violation or corruption is a violation of human rights. And I agree perfectly with that. Human rights is cross-cutting. And I guess that is why the framers of our constitution found it necessary to form an institution called the Commission on Human Rights and Administrative Justice. We have a 3-pro mandate that is given to us under our constitution. And whilst other speakers spoke, I was very touched. And how I wish, especially my lady in red, how I wish you were in Ghana. I will just tell you, come quickly and report to Shraj, and we'll take your matter up. I spoke to Cynthia. Was the institution you were working with, was it a public institution? She said, yes. I said, I wish you were also in Ghana. What about Martha's case? She said, yes, it's a public institution. The Commission on Human Rights, we are the National Human Rights Institution. We also are the Ombudsman in charge of administrative injustices. And then we are the Anti-Corruption Agency, also in charge of corruption, combating corruption in Ghana. So you can see the link, isn't it? There's a link with administrative injustice, just as she suffered, just because she blew the whistle. Administrative injustice meted against her. The commission has that mandate. Apart from the constitutional framework, that's the mandate under the constitution, we also have some statutory responsibilities or statutory powers. And one of them is what Stephen will touch on, because our powers in terms of whistleblowing is under the Whistleblower Act. And it's a statutory power that has also been conferred on the Constitution. We have other statutory mandates that we also undertake. For instance, under the Children's Act, we have a mandate there. Juvenile justice, we do have mandates. So we have various mandates. In one of the submission of the speakers, I noticed we're looking at ways of how to come up are we going to get a different institution apart from the Human Rights Commission to standing as a protector of whistleblower? Or what is the way forward? We would talk about the gaps. We don't have a perfect system though, but it's a good system. And the good news is that everything we do at the Commission on Human Rights is free. I'm hearing having to take lawyers, having to pay for lawyers and all that. All that we do in the commission is free. So citizens come to us in confidence. Someone touched on the issue of confidentiality. We have a confidentiality policy. And so persons working with the commission are mandated to make sure that issues that come before the commission are held tight. Very, very important. So under the same constitution, we also have this clear mandate under Chapter 24 as the ethics body. Apart from the corruption, we are also the ethics body for the public service. We take asset declaration at the beginning of any public officer taking office, including the political office. You're supposed to declare your assets. It is the commission that monitors that. It is the commission that you can report to if you think that a public officer has failed to declare his or her assets. Why do we declare assets, or why the requirements for assets? Because we need to monitor how you're making money and where you are getting money from. Of course, when money is meant for the poor, the marginalized, the needy, is siphoned, human rights violations occur. And therefore, we see the link in all these things, very, very important. So we are also, the code of conduct for public officers, it is the commission, because we also, someone said it's very important that the public officers, they do their work and do it well. There must be some kind of code of conduct to guide the work they do. And it is our responsibility to ensure that if any public officer has failed in his duty to do what is expected, you report to us as trash. We have a plethora of cases we've handled in that area. Conflict of interest, the most important, you may have heard. Even sitting presidents, we have the power to investigate. We've investigated sitting presidents who have been cited for conflict of interest and all. And like I've mentioned, our services are free. So you don't come there, thinking of how much am I supposed to pay or that. So just a quick reflection on that. Breach of oath of office. We also have that mandate. It's very, very important. So there's a link. And when you look under the whistleblower, which Stephen will come and elaborate on, we actually have the mandate of the High Court under the Whistleblower Act. Where there is victimization, as we have heard, our orders are equivalent to that of the High Court. So you can imagine if you are blowing the whistle, you are assured of some kind of protection, isn't it? It's very, very important. Now, also, under the admin justice mandate, as I mentioned earlier, it is in respect of public office or for public servants. In fact, Article 23, that public servants and public bodies are supposed to work within the confines of the law, setting them up. It's supposed to check this, how you apply discretionary power, Article 296 of our Constitution. And so public service, we say, what they do there is not unfettered. It is not unfettered. Whatever they do, they are accountable to the people of Ghana. Very, very important, to the citizenry. Their duties and their mandates and their recommendations and decisions are not absolute. They are accountable. And because of that, when you report a matter, we are able to go in. If my lady was in Ghana, we will recommend an interim decision immediately for her reinstatement, ask for police protection for her immediately, and it will be done. And it will serve as an incentive for others to also, tread that path to show that they can also, because under our law, when you are reporting issues regarding whistleblowing, It's actually a human rights thing. You are a defender because what you are saying and the wrong within the institution is something that will cost the state. So you're actually protecting the interest of the state, and it's very, very key. And just to conclude, because of time, and Stephen will come and discuss further so that when questions come, we can answer. Just to conclude, I want to say that sometimes Africans, we pass a lot of laws, but enforcement is an issue. The laws, we have fine laws in the books. Parliament passes a lot of laws, but enforcement is the key. And I have also learned something from here. Apart from the protection of the whistleblower, we also need to look at the station, the status of the whistleblower. It's something Stephen will touch on. What happens subsequently? I heard psychosocial therapy and all that is something we are also taking home. We have also learned something here. So enforcement is key. As a human rights institution, our decisions, when it comes to human rights, admin justice, our decisions, we go to court to enforce. That is, if it is not implemented by the institution which is required to do a thing, and more often than not, the courts have, upheld our decisions, and we have had results. When it comes to corruption, we look at allegations and even suspicions. Allegations and suspicions. So when it's suspicious, sometimes we don't even need a complainant. When I hear something on the radio, I can move into that public institution and start investigating. It's based on suspicion, isn't it? But when it's an allegation, then we may need someone to come in to report to us. And that is the assurance I gave earlier that you are protected at that level. So just to end here, that all the issue we are discussing relates to human rights. But human rights is cross-cutting. Admit justice under our constitution is a human right. Corruption is a human rights issue. Whistleblowing is a human right. So you can imagine why even a statute, they had to give the charge, our institution, the mandate to conduct investigation, and then the sole mandate to also investigate victimization of whistleblowers. Thank you very much. All right, so we also investigate conflict. And there's something more you want to add.
Which one? No, it's okay.
The involvement of the private sector in combating corruption. We have a national framework we call the NAC, but we thought that bringing in the private sector to help in combating corruption is necessary. So when you take the NAC, most of the private sector, they have certain duties and reporting obligations to report to us as to what they are doing to ensure that corruption is kept. Thank you very much. Are you fine?
So there's a saying that what men can do, women can do better. It's in Ghana. Yesterday was International Women's Day. And we celebrated it in Ghana at the office. Unfortunately, because we were preparing to come to South Africa, we couldn't attend that program. But when I came here and I saw Cynthia and Martha speak, I said, look, this is the real meaning of International Women's Day. Congratulations for the efforts. Yes. So whistleblowing has become a problem. And it became a problem because of the fact that, and I'm happy that when this conference started, we all spoke about the dangerous effects of corruption. In Ghana, there was a culture, or there's still a culture. People say, if somebody doing something, that's that person's business. In other words, the saying is, don't mind your own business. Now, because of the mind your own business attitude, people were not prepared to come to CHRI, to Commission on Human Rights and Administrative Justice, to report, what do you call it, acts of corruption. Apart from that, our cultural system was such that, people thought that, look, if I go and report somebody who's engaged in an act of corruption or an illegality, the whole society will turn against me and say, oh, why are you doing this? After all, is it your family matter? Is the government for you? Is the state in your pocket? So why are you bothered about this? So it was based on this that the state decided, look, we need to have a whistleblowing act. So the Whistleblowing Act came in 2006 to cure the defects of the refusal of people to report on acts of corruption and other forms of illegality. Now, our act is entitled the Whistleblower Act 2006 Act 720. And if you look at the preamble to the act, it tells out clearly what the act is supposed to do. With your permission, let me read. It says that the Whistleblower Act is an act to provide for the manner in which individuals may, in the public interest, disclose information that relates to unlawful or other illegal conduct or corrupt practices of others, to provide for the protection against victimization of persons who make these disclosures, to provide for a fund to reward individuals who make the disclosures, and then to provide for other related matters. So right from the word go, we have our act says that, look, it's an act that wants to encourage people to disclose information in the public interest. But if you have disclosed information in the public interest, then there ought to be a mechanism to protect you. So the Whistleblower Act provides for that. But apart from that, it goes further than that. Look, that after you have disclosed information about an illegality, you are supposed to be rewarded for it. So like in the case of Cynthia and in Ghana, your efforts will have been rewarded at the end of it all. And the reward will come in the form of financial compensation for all the trouble that you're going through. That is the situation that we have in Ghana. But then, you see, because of the type of environment that we find ourselves, there are a lot of people who normally want to take advantage of things. So our parliament has clearly tried to define who a whistleblower is. So that before you can take advantage of the provisions of the act, before you can go and say, look, I have done this and I want to claim compensation, you have to come within the regime of the act. So who is a whistleblower in Ghana? Now, our act says that a whistleblower is somebody who has disclosed information related to 4 good things. 1, that the information that you disclose should relate to the fact that an incorrect crime has been committed, or is about to be committed, or is likely to be committed. So you don't wait for the crime to be committed. If you think that looking at the way things are going, there's likely to be the committer of a crime, you can go and make a report. You don't need to wait for it. Or if you think that, look, the thing is likely to happen, you don't need to wait. You can go and make a report. Then the act also talks about non-compliance with the law. That if another person has not complied with the law, or is in the process of breaking the law, or is likely to break a law which imposes an obligation on that person, if you have information on a situation like this, you can go out and make a report. And when you make a report under those circumstances, you become what? A whistleblower. It also says further that where there's an occurrence or likely occurrence of a miscarriage of justice, if you have information that indicates that, look, a certain event is taking place or something is happening, and if that thing happens, it may lead to what? A miscarriage of justice. You don't need to wait for justice what? To be miscarriage. Before you make a report, you can go and make a report. Then it also talks about the occurrence or likely occurrence of waste, misappropriation, mismanagement of public resources in a public institution. So if you have information that there's going to be mismanagement of public resources, there's likely to be what? Misappropriation of public resources, you don't need to wait. You don't need to wait for the event to happen. And of course, it also says that if you have information that the environment is what? Degraded, or is likely to be degraded, or is what? Is being degraded, you can also make a report on that situation and you become a whistleblower. Lastly, it's also say that if you have information that says that the health or safety of the individual or a community is likely to be endangered, or is being endangered, or it has been endangered, you can also make a report. When you make a report under these circumstances, you can become also a whistleblower. But then the Act also says it's not everybody who can make a complaint that can become a whistleblower. So it gives three instances. First of all, it must be an employee in respect of another employer, or you're an employee in respect of your employer, or you're a person in respect of another person or an institution. You see, very difficult language. When you come to the gaps in the implementation of our law, you'll understand why this is a difficulty. Because instead of just look, everybody can what? Make a disclosure. It tries to list three circumstances under which a person who makes a disclosure can become a whistleblower. Now, but to whom can you make a complaint to or a report to become a whistleblower? Our Act has given 80 institutions or persons to whom you can make a disclosure of impropriety or a disclosure of the circumstances that I listed. And those institutions, 18 of them, it includes the Commission on Human Rights and Administrative Justice, the Attorney General, the Office of the President, Office of a Member of Parliament, the media, it also includes chiefs, an elder of a family, or a head of a religious body. But there's a caveat. The caveat is that when you have information of an act of impropriety and you make that disclosure to a chief or a head of a religious organization or an elder of a family, their duty is just to tell, look, please, go to the police. Here we have the information, but we'll lead you to the police so that you can go and lodge the complaint properly. Or we'll lead you to the institutions that have the capacity to investigate the complaint so that your complaint can be properly handled. The law also says, and interestingly, that you can make a complaint to one or two of these institutions. So not just one, but that is where the danger is. And when I come to discussing the challenges in the implementation of our law, you will come to understand why this is a challenge, that you are a whistleblower and our law says you can go to the police, at the same time you can come to church, at the same time you can go to media commission. Now, there are certain requirements in terms of the procedure and in terms of the mode and manner in which you should lodge a complaint. These procedures are not cast in stone, in the sense that the Act says that yes, if you are going to make a complaint, your complaint should contain what we may call your full name, your address, your occupation, the nature of the impropriety or the nature of the conduct that I spoke about, and the person alleged to have committed or was committing or is about to commit the impropriety. But the act says that, look, you need not meet all the requirements of this, what do you call it, or the full requirements of what are of these elements before you can become a whistleblower. And I'll just give you an instance. Shortly before we came, that was just last month, there was this complaint that came from our what do you call, electricity company. Apparently, the management of the company and staff of the company were engaged in what we call illegal claims of overtime. So an employee decides to blow the whistle. When he blew the whistle, he didn't put his name there. He just put his telephone number there, believing that by putting only his telephone number, he will be protected. Unfortunately for him, the people who were at the center of it managed to Google, and they contacted the telephone service, and they were able to know the employer. So then he was exposed. What did he have to? He has to run to church for protection. But as Mary said, we have the power to what do you call, inquire into acts of victimization. I will touch on that. So we decided, yeah, this was a whistleblower, although his full name was not there, although his address was not there. The substance of it is that there was an identity. Unfortunately, the confidentiality that he wanted from the institution had been exposed. Now, I have to realize is that because our society is not fully literate, you can make an oral complaint. But when you make an oral complaint to an institution that has had the capability to engage in an investigation, your complaint must be reduced into writing. So you need not write the complaint, or you need not make the disclosure in writing. You can make it orally and then it will reduce into writing. But then, there's this thing that I'm skipping some of my what you call slide because it may not be necessary for now. I wanted to touch something about the role of the Attorney General in terms of investigations in Ghana or whistleblower complaints. Our act says that for every complaint that has been made on an impropriety, a copy of it must be submitted to the Attorney General. So when you make a complaint, or when you disclose, or when you blow the whistle to an organization such as Church, what the Church is supposed to do is that within 7 days of it receiving the disclosure, it has to make a copy of the complaint to the Attorney General. That is problematic. Problematic in the sense that in Ghana, we have a situation where our constitution fuses the power of the Minister of Justice and that of the Attorney General into one person. So the Attorney General and the Minister of Justice are one person. So when you blow the whistle against an act of impropriety that is being committed by a Minister of State, and a copy of that complaint is given to the Attorney General, can you imagine what will happen from day one? You will start drawing cycles against you. But that is not all. It also says that even after you have done the investigations, you must give a report to the Attorney General. So all the 8 institutions that have been listed, if they conduct investigations into whistleblower disclosures, the report goes to the Attorney General. Whether the Attorney General will work on the recommendations because the law doesn't compel the Attorney General to act on the recommendations that you are making. And we have had those. That is one of the challenges that we are facing in Ghana in terms of, you see, our constitution creates Church as an independent organization. Apart from Church, Media Commission is supposed to be independent. There are some other independent institutions. So when you conduct an investigation as an independent body, and then you're supposed to give your recommendations to a body to which you are not supposed to be answerable to, and that body refuses to act on the recommendations, what do? Your hands are tied. That is why sometimes, and I think that the South African Commission, once you are engaged in trying to formulate a legislation, you maybe have to be mindful of this. That sometimes when somebody comes, he wants to blow the whistle. we then have to educate the person that, look, yes, very good case, but this is the danger. If we conduct our investigations and finish with everything and go to the Attorney General, it lies there. So sometimes some people, once they get the education from us, they rather prefer that it comes to the Commission on Human Rights and Basic Justice as a complaint, and then we'll deal with it, under our own law instead of coming under the Whistleblower Act. So powerful is the Attorney General in Ghana that even when there are delays, you see, our Whistleblower Act says that if we receive a complaint, you are supposed to investigate the complaint within 60 days. Your investigation should not go beyond 60 days. So, in the event that your investigation is going beyond 60 days, you will have to write to the Attorney General and explain to the Attorney General why you are your investigation is going beyond 60 days. You must provide reasons, and then also, give a roadmap to the Attorney General as to how you're supposed to conduct that investigation into that particular illegality, expeditiously. Those are the dangers that we face. But I don't want us to touch on the protection mechanisms that exist in Ghana. And the institutions that are responsible for protecting whistleblowers in Ghana are basically three. We have the police, the Commission on Human Rights and Basic Justice, and our traditional courts. And I want to emphasize more on the Commission on Human Rights and Basic Justice. But first of all, the law tells, or it gives the circumstances under which somebody can be considered as being as being confronted with an issue of victimization. It is not every instance that can arise that will give rise to a cause of victimization. So the law gives a particular criteria. What does it say? That victimization arises where, if you are an employee, you are dismissed, you are suspended, you declare redundant, you are denied promotion, you are transferred against your will, you are harassed, you are intimidated, you are threatened, you are subjected to a discriminatory or other adverse measure. That is if you are an employee. If you are not an employee, if there's discrimination against you, if there's intimidation against you, or you are harassed by a person or institution, merely because you have made a disclosure, it is only then that you can be considered as being, victimized by whoever is engaged in the act of victimization. So when that happens, what do you do? Our law says that if someone realizes that he's being victimized, or even thinks that he's going to be victimized, what he can do is he can come to Commission on Human Rights and Basic Justice and lodge a complaint. And once you lodge a complaint, the Commission on Human Rights and Basic Justice is supposed to do what we call an inquiry. It doesn't even use the word investigation. We're supposed to conduct what we call an inquiry. Here we conduct an inquiry in which the whistleblower and the person against whom the complaint has been made will be heard. And there are a lot of cases that are currently ongoing where we are conducting inquiries into whistleblower victimization complaints. The danger or the difficulty here, and I believe some other speakers have spoken about it, is this. What happens if a whistleblower comes, indicates that he's being victimized, and the complaint is against the employer or against somebody who has so many resources? The person appears with a huge retinue of lawyers, as it happens. 3-4 lawyers to defend him. The whistleblower is there, he has no lawyer. What happens? So, fortunately for us, the law says that we should not allow technicalities, to prevent us from carrying out our inquiries. So you have situations where lawyers will appear before us at an inquiry and they raise all manner of objections, my lord, madam. At the end of it all, we say, no, please, we are interested in the substance of the matter. It is not about our technicalities that should matter here. So that is the good thing about the inquiries that are conducted before church. So you may not, if you don't even have a lawyer, you come. We will give you protection. Sometimes we tend to, although we act as umpires, we try to even protect the whistleblowers at that particular stage. But it's a difficulty because the whistleblower already, psychologically, once he sees a written law, he feels defeated. Now, but what can CHRI do apart from just conducting an inquiry? It says that when a complaint of victimization is brought before us, we have the power to make what we call interim orders. So take, for instance, if you are an employee and you have been suspended, or you have been intimidated, or you have been harassed, sometimes happens to women, you have been sexually harassed because you have blown the whistle. Once you appear before church, we can make an interim order. If it is a case of suspension, we can make an interim order to indicate that you should be brought back to the organization. Would vacate your suspension. If that is about dismissal, we can look. Let's take this dismissal. Let us go into the matter and determine the merits of it before we make a decision on it. So that is a saving grace for whistleblowers in Ghana. But as you will notice, the instances under which the Commission on Human Rights and Administrative Justice can give relief to people in terms of victimization cases, and I know that it's quite narrow. When I come to the gaps, you notice why I'm saying this. But our act says that the orders that are made by CHRI or by our Commission on Human Rights and Administrative Justice in terms of whistleblower victimization complaints are equated to the orders of a high court. Yes, so when we make an order reversing a dismissal or asking a particular organization or an employer to pay so and so, or to take an action in favor of the whistleblower, our order becomes an order of the High Court. And it is enforceable in the same manner as an order of the High Court. So when it happens that way, you can't go to a lower court to disturb the decision of CHRI. If you go to the High Court, they'll simply point out this, look, this matter that you have brought, the order is the order of our own court. So you can't come to a high court. Perhaps you may want to climb higher. But as Mary indicated, many of our decisions are normally upheld by the courts. And that is what gives us comfort to do the work that we are doing. Now, but what of the traditional courts themselves? As I indicated, the courts too have a role to play. You see, the Act says that, nothing prevents a whistleblower from going to court. I mean, a whistleblower who has been victimized from going to court to ask for damages, to ask for any relief. Just that before you can go to court, you must have first filed a complaint before CHRI. So, as it is, in terms of original jurisdiction, lawyers who are here will understand that CHRI, we have original jurisdiction in terms of victimization complaints. Even before, if you go to High Court without come to CHRI, they will send you back to the Commission on Human Rights and Administrative Justice. But even once in the course of investigation, for those institutions that do investigations, if they are doing an investigation into whistleblower complaint or disclosure, and it is realized, at the most happens, that some institutions are not prepared to give you documents, they're not willing to assist you in terms of the evidence, you can go to the High Court and apply for an order directed at those institutions to give the evidence, and then they will have to comply. Now, another thing that I want to, and I indicated in terms of the reward system, our Act has created what we call a whistleblower reward fund. Now, this whistleblower reward fund is a fund that is supposed to be, resourced by the Parliament of Ghana. So the Parliament of Ghana is supposed to normally set aside some amount of money into the whistleblower reward fund, so that when whistleblowers find difficulties, they can be compensated from that reward fund. Just that the weakness in our law is that it says that if a whistleblower makes a complaint about an illegality or an act of corruption, and there's a prosecution, it is only when there's a conviction that the whistleblower can be rewarded. Can you imagine what that means? The whistleblower is not in charge of what? The prosecution. He's not in charge. He's not the Attorney General. He doesn't determine how evidence is led. He has money to disclose an act of impropriety, and then you say, look, wait, when there's conviction, then what? We'll reward you. That is something that discourages people from wanting to disclose acts of impropriety. Now, so in terms of the challenges, I've already mentioned some of them. There is what I may call some lack of transparency in the procedures that investigation bodies are supposed to use. And I'll say this because when whistleblowers come before you, they are vulnerable. So sometimes they want to know what is going to happen to them. What type of procedures are available? At what stage can they be heard? At what stage of investigation will they come into? Who are going to be invited? They need to know all these things. Unfortunately, the law has not made provisions for that. That is something that we need to think about. Whistleblowers who come also, they need guarantees that there will be fair investigation. Because if they don't, if they're not, if they know that at the end of it all, there will be unfairness, then there will be no point. As I said, if the whistleblower knows that, look, this complaint that I've brought to this institution at the end of it all is going to rest at the bottom of the Attorney General, and it's about a Minister of State. I know the Attorney General, as I said, is the same thing as the Minister for Justice. He would not like to send his colleague minister to, he would not like to punish his colleague minister. If the whistleblower already knows this, then it's become what? It is disincentive for making disclosures. Indeed, our law says that the act, there are supposed to be regulations, elaborating how the act is supposed to be implemented. As we see today, we still do not have regulations governing, our whistleblower law in Ghana. We are still awaiting the day that the Attorney General will make those regulations. Of course, I've also indicated that, yes, the law says there has to be a reward fund, a whistleblower reward fund. But as we stand today, that fund is yet to be established. Can you imagine that the whistleblower law came in 2006, but till date, the politicians have a different way of looking at things. But most important is the lack of sensitization. Ignorance about the existence of the law is key. And I want the South African Human Rights Commission to notice that you can have all the good laws, but if the people do not know about the existence of the law, if they don't know that there are protection mechanisms in the law for them, if they don't know that they don't know the type of institutions to which they can make reports or complaints, then the law becomes useless. So, and if you come to realize that ever since our whistleblower law was passed in 2006, our whistleblower cases have not been that many, simply because there's lack of sensitization. But more crucially, the law itself has not indicated which institution is supposed to do the sensitization. It just gives 8 institutions, look, these institutions can do investigations, period. But who's supposed to educate the people on the whistleblower law? Nothing. It just leaves like that. So what now happens is we have some NGOs or civil society organizations which have taken it upon themselves to go about educating people on the whistleblower, but they themselves, they don't have the technical expertise to do the education. That's one of the challenges that we face. Of course, the law itself hasn't got provisions protecting investigators. It will surprise you. that we, those who investigate whistleblower complaints, find ourselves at risk as well. Because if you are investigating His Excellency the President, can you imagine the risk that you are exposing the institution? The financial risk that you're exposing the institution. The social risk of your staff. I know some time ago, I will just give you an instance. In 1996, this was not a whistleblower complaint. We had investigated 6 ministers of an administration. It was the NDC, you remember. While the investigation was going on, the investigation wing of the corruption fire caught the place and burned down everything. Yes. That should tell you the dangers that institutions face. So it's important that when you are coming out with legislation, you must have protection mechanisms, not just for the whistleblower themselves, even for the institution. And the issue of financial independence is very, very, very important. I'll tell you, that was when we were making some investigations. And that year, so fine, we gave a budget, but there's no money, so they cut down the budget. Just to make sure. It's a way of crippling you. That is the danger that institutions face. And I think that it behooves on all of us to come together to fight this type of system. There are also provisions dealing with mandate overlaps. I've indicated that the law provides that you can make a disclosure to one or more institutions. So what happens if a whistleblower goes to the police to make a complaint? He goes to council church to make a complaint, goes to National Media Commission to make a complaint on the same matter disclosed. So the 3 institutions, which of them is supposed to do the investigation? And if they are doing the investigation, they may want to view the investigation from different perspectives. That is a weakness. We are of the view that at least the law should mandate that the complaint should be filed with one organization. So that at least at the end of, right from day one, you know which particular organization is in charge of investigation, so that organization can be held accountable for whatever investigation that they're doing. And of course, we don't have provisions dealing with relatives. Why is I don't know why I keep forgetting your names. Maybe Cynthia and Nota. I did not hear you talk much about whether your relatives are being harassed, they are being intimidated. Oh, she mentioned it. Okay, yeah, she mentioned it. But it's a problem that if you want to fight a system and the system is fighting you back, they won't fight you alone. No, never. They'll make sure that they'll put you in such a state that your family will even come and plead with you and tell them, hey, please, this thing that you're doing, stop it. So in flashing our whistleblower mechanism, we need to think about the relatives, family, friends. We have to protect them as well. And the protection should come in several forms, giving them education, letting them know what is happening, telling them, what they are supposed to expect. All these things are very important. Let me also indicate that one of the powers that as a commission we have, which are almost escaped, is the issue of granting people police protection. If a whistleblower comes and makes a disclosure of an impropriety, and we look at his story and we think that he deserves police protection, we make an order to the Inspector General of Police, please give this person protection. And we have done that on certain occasions. Currently, there's somebody who's a whistleblower who's under police protection, 24-hour guard police protection. He has it. Yes. Right. But you see, is police protection enough? You ask yourself. A whistleblower who has made an allegation against let's say the Minister for Justice or the IGP himself, and there is the IGP who's supposed to give him protection. How will he trust that system? How will he trust it? And there's also a weakness where we don't have provisions where the whistleblower himself is an active participant in the act of impropriety. You know, some people are clever. They engage in the impropriety, and when they realize that they are not getting the benefits of it, then they tend to be whistleblowers. We have those institutions. But the law hasn't taken notice of that. It's something that we need to think about. So in the face of these teaching problems or challenges, what are we doing in Ghana to mitigate the challenges? One, firstly, there's a bill in Parliament seeking to amend relevant provisions of our whistleblower law to take care of the difficulties that I've mentioned. Unfortunately, and it's interesting that this bill has been pending in Parliament since 2013. Yes. 2013 has been pending. It doesn't appear as if people are enthusiastic. But as a commission, we've decided this year that as part of our work plan, we are going to fight for this bill to pass so that people can feel confident that when they are making whistleblower complaints, they know that there will be fairness in the investigation. They will be well protected, they and their families. In addition to that, as a commission, we are collaborating with the UNODC, the United Nations Office on Drugs and Crime, to develop what we call standard operating procedures for whistleblower protection in public sector institutions. We are saying that if we want to wait for politicians, we will not achieve what we want. So let's develop standard operating procedures so that, when whistleblowers come, they know what they are coming to meet in the institutions. We can infuse confidence into whistleblowers so that they will keep on making complaints. We have also established what we call Key Accountability Institutions Forum. The Key Accountability Institutions Forum is a forum made up of all institutions that have the capability of fighting corruption. So we have brought them together. There are about 12 of them in Ghana, and we have established a forum. The idea is for us to exchange information and to collaborate, for the institutions to collaborate among themselves in the fight against corruption. So when that happens, if you make a complaint, if you disclose an act of impropriety to one or two of these institutions, once there's a collaboration between us, we will determine which particular institution should do this investigation so that the issue of mandate overlaps can be taken care of. So these are the few things that we are doing in Ghana. I must give respect to what we learned from the PDA of South Africa and of course the South African Commission. We've learned a lot. I think that collectively we can do together in Africa to ensure the protection of whistleblowers. Thank you very much.
Please, if you can take the mic, I can bring it to you.
Just to add a small part. I think one of the issues we faced during initially an investigation of whistleblower case was the issue of the whistleblower himself going out into public declaring. So you come to the commission that you are a whistleblower and we are supposed to protect you, your identity and everything. Then subsequently, the whistleblower himself now goes to the media to announce. So once you do that, then you're no longer a whistleblower. I hope you understand. So in the law, we saw that lacuna, that there must be some kind of obligation on the whistleblower that once you blow the whistle, you are mandatorily requested to keep your mouth shut and also protect yourself. You don't now go into public and start announcing. You are no longer a whistleblower.
Thank you. Let me readjust. Thank you so much, Stephen and Mary. I do see a few hands. I recognize you. I just want to mention that we were due to be joined by colleagues from the Whistleblower International Network. I understand that Anna was urgently called out to an engagement in Geneva, so she had tendered her apologies. And then the other colleague is facing some technological challenges. He is based in the USA. As soon as they are available, I'll try and connect them. Kiba, we haven't received, there's just some technical issues. But as it stands, we will proceed. I note hands from the floor. Thank you, Stephen, particularly for the multi-sectoral elements that you brought. I do recognize Martha. Quite a few hands here. This is great. Okay, let me just, so I'll start on my left, if that's okay. 1, 2 in the back, 3, John. And so I'll take that first 3, if that's okay. Followed then by Ms. Mbeki. My apologies, my sister, Tabile, and then my colleague, Kyle. So this is the second batch, and then the first. Please, are you comfortable coming up? Yeah, so please do.
Thanks for the opportunity again. I think for me, perhaps maybe we can look at how we deal with this scenario. Take, for instance, in our case, and indeed the identification of whistleblowers is a concern that is there. However, in this particular case, do you know the fights we had with the State Capture Commission to say you are bringing us out? Tiro, for instance, asked that specific question to the commission to say, what protection are you going to give to my family? And then what happened? We were subpoenaed. And this is now a public forum. So how do you then, deal with that conundrum where the law expects, because if you don't, we know what happened to the previous president. He was arrested. Who am I as Mathangoi to refuse to go and appear at the commission, even though I know the challenges that are there as far as the identity is concerned? Because immediately the organization knew that we were the ones that went to the State Capture Commission. There was that bullet. I mean, at one point I had to, when I applied for leave after the first appearance of the commission, because the pressure and the stress, my boss said to me, you must account for the time you were at the commission. So, how do you deal with that conundrum where it is what it is?
John, my sister in the back. If you're not comfortable being on the podium, then you're most welcome to speak from there, except you won't be shown on the monitor. So you prefer staying seated. Okay. John, you comfortable coming up afterwards? Okay. So just as soon as she's done. Thanks.
Good afternoon. Thank you very much. My question is linked to the issue of identity, and especially with initial receivers of disclosures. Looking at the Act, it says that one can actually disclose with the head or an elder of the family of the whistleblower. How does that really work? I mean, I know in the morning we were considering expanding a range of, of institutions and persons that can receive disclosures, and I can see in Ghana you have, but how does this really help? Like, how does it work?
John?
Thank you for a very interesting presentation from Ghana. It's so nice to feel that we're not alone, and there's an African context. And it just reminds me that years I spent with the World Health Organization working in Africa, and there's such a latent potential for us to realize if we collaborate. And it just stirred that memory of, and hearing your accents, and that just made me feel nostalgic for that. But my question really is about media. In a submission I made to the Zonda Commission, from my experience of having spent a lot of time with whistleblowers, we suggested that there needed to be 3 pillars of any effective protection and support mechanism. There needed to be obviously statutory reform and proper legislation, and secondly the psychosocial, and I actually would also argue spiritual support, because it's in a spiritual ordeal, and I mean I happen to also be a Christian and a theologian, so actually I don't know how people sustain themselves without some sense of a transcendence. But then the third one has been the media. The media must be a safe harbor for whistleblowers. And I know Thandeka, what she did at the SABC was to make sure that through her long battle with the others, to make sure that the public broadcaster wasn't captured as well, that was able to free up. But the question still remains that, that it's about human rights. I mean, it's freedom of expression, it's access to information, it's free reporting. And I keep going back to it, but my sort of training ground for what I've done here has been my work with the Amadiba and the Wild Coast. And thank you, Cynthia, for honoring Bazuka Khadebe and Nwanshle Mbutuma and the people that have been so powerful there, is because we had the media. And the media were able to give ventilation to that story, so that when eventually they got to court, the judge ruled in their favor. Said, yeah, right to free, prior and informed consent is a constitutional right. It's because she knew what it was all about. The story had been told. So I wanted to say, in a sense, there's probably a follow-up conference needed if we're going to have a sort of a true sense of consolidating protection of what role can the media play. And I'm particularly intrigued when you said that if you disclose to the media, well then sorry, you're not a whistleblower anymore. I mean, that I found that strange. Although I have to say that what's been really wonderful as a social worker is that people can disclose to a social worker. They can tell your story. They know it's confidential. And then what I found with the Kolobeni story, I would then share the story with the Amadiba. I mean, with the media, and the media would then connect the dots, and they were able then to the various journalists we worked with to assemble a plausible an understanding of what the complexity of that situation was. And it was a very useful role to play as a social worker in partnership with journalists of how we could then wash each other's hands. They could share with me information that they couldn't publish yet because it wasn't yet confirmed to test. I could then test it. And then, of course, the whistleblowers weren't known. They were there, and so it filtered out. They weren't, well, they weren't, a lot of them are still not known. And the last point I make, you just prompt me. The reason I reminded why I got involved in this particular work is because I still feel a sense of unfinished business in my work with the mining and the Kolobeni Amadiba communities, because I know that there's a potential whistleblower there who has the information I need to confirm my hypothesis that there was a corrupt deal made with the Australian mining company way back in 2002 for the Kolobeni mining rights. Now, I can only present that now as a hypothesis, but I know that it's true, but that person doesn't feel confident enough to come out, partly because they feel tainted, because they were complicit in it, and partly because they don't want to get killed. Thank you.
Thank you very much for that very fascinating insight into the legislative framework of Ghana and its challenges. It seems to me that we share a number of challenges, and that the meaningful constraints to whistleblower legal reform lie in the toxic politics of African colonial societies. And even the lack of our ability to implement reforms and even pass a bill or even set up a fund and appropriate money through the Appropriations Committee of your own parliament. We've got similar challenges on this side. So it would seem to me that if we were to look at Ghana and your neighbors Benin, and we look at Nigeria, and we go all throughout ECOWAS, would find the same story, because we've seen echoes of ours in yours. Is there a way that the human rights commissions of our continent, at least those that have got working relationships, can kick it up a notch or two and take this matter and increase its political profile on the continent by tabling a debate at the AU and asking, as the press did, for a special rapporteur and a continental protector of whistleblowers, and giving, as the Europeans have done, issuing an African note, as the Europeans have issued a European note, giving ideal forms of legislation that can lead to protection of whistleblowers throughout. Because a death in Ghana, if I fall in South Africa, a whistleblower has fallen in Ghana too. Thank you very much.
I was just going to say, we were just supposed to take the 3 and then move on to the next. So I'm going to just pause the 2 questions here to allow Stephen and Mary to respond while they come up. There's also a question around how do you deal with a situation where the whistleblower reports the allegations simultaneously to different responsible enforcing officers, for example, Media, Human Rights Commission, Presidency, etc. And Martha and all the other whistleblowers who are present, there has been an offer from Nalini Maharaj, adding on the comment earlier, where they are, it reads, Madam Martha Ngoyi, Advocate Ben Wicks and myself can assist you. Please contact me. They've left their details, which I'll share. We can assist all whistleblowers, including suing for damages or defend action taken against you on condition that you have good merits. So I will share that information with you. The comment is duly noted and appreciated, or rather Nalini Maharaj. And then Pascan, I do note your request for copies of some of the discussions today. Stephen, you're welcome to respond, and then we'll take the next 2.
So thank you very much. If I would start addressing the comments or questions from the last one, which dealt with the simultaneous reportage to one or more institutions. As I've indicated, in Ghana, we have established what we call the Key Accountability Institutions Forum. The Key Accountability Institutions Forum is a forum made up of investigation institutions in Ghana, 12 of them, which have the mandate to investigate corruption and other forms of crime. The idea is that we need to come together. You see, corruption is so huge that no one particular institution can fight it. I think that has been made very clear. That if you think that you set up only one institution to fight corruption, it will fight it alone. Because the nuances of corruption are so many. So you need collaboration from many institutions to be able to fight it. So this is what we are doing in Ghana. We will collaborate, we exchange information. So where a particular disclosure is made to one or more institutions, the Key Accountability Institution Forum will come together and say, look, looking at this complaint, it is better that this institution handles it, or we break down the complaint depending on the legs of the complaint. You handle this aspect of it, you handle this aspect of it, but this particular institution, you be the lead investigating agency. Or this particular institution, you do the investigation. When you need information or support in any form from any of the key accountability institutions, come to us. So at the end of it all, once a complaint comes in that form, the key accountability institutions will identify one particular organization which will deal with it so that we will overcome the issue of mandate overlaps. Now, there was this question that has to deal with the reportage in the media. I think that my colleague probably was not understood. You see, the thing has to do with the protection of the information. When you disclose an impropriety, the information is supposed to be protected. Your confidentiality is of what? To protect it. So, if you then decide as a whistleblower to go to the media, you have lost what? Your confidentiality. The information that you have given to that particular institute is no longer protected. So it doesn't mean that you lose your identity as a whistleblower, but you will still be a whistleblower, all right. But your confidentiality can no longer be guaranteed. You have decided to expose yourself. But as I said, it's the issue of education and sensitization. People must know this, that once they bring a complaint, it is a whistleblower, look, they must know that, look, don't go and then what? Expose yourself. Because when you expose yourself, there are certain dangers. You put yourself at what? At risk. And that is why it's mandatory for institutions in Ghana who receive whistleblower disclosures to keep the information confidential. There are sanctions in the law, criminal sanctions, that when you expose a whistleblower, you are liable to imprisonment to a term of imprisonment for no less than 5 years. Yes, that is what the law says. So it's like a sort of Damocles that is hanging on the necks of investigations institutions that are supposed to handle whistleblower complaints. That you don't receive a whistleblower disclosure and go and sit in a beer bar or go and sit on radio and talk about it. If you expose the whistleblower, you are in trouble. All this is to protect what? The whistleblower. Then there was this question that dealt with the identity issue of an elder of a family or head of a religious institution, where a disclosure is made to these persons. Of course, the law recognizes that these are persons who do not have the capability to carry out investigations on what you call whistleblower disclosures. But we must recognize that our people there, you see, there are some people who trust their chiefs. They trust their religious leaders. They trust the head of families more than your South African Human Rights Commission, or more than they trust them. So they may want to go there and say, look, this is happening. This particular company is engaged in environmental degradation. This particular company is dumping waste, and the waste is affecting our community. They are confident that the chief will do something. So what the law says is that, look, because the chief hasn't got the capacity, you simply lead the particular person to the appropriate institution or to the police who will take up the investigation. And that way, the whistleblower knows that, yes, he has some support behind him. It's not as if he's just making a call. There's a chief, and once the chief is behind him, who else can go and get the chief in that community? I know people are funny. There are some people who collude with companies to degrade the environment, to disturb water bodies. They do all manner of things. Some people benefit from it. That's all about corruption. So when it happens, when a complaint comes in that form, you simply go to the institutions which have the capability or capacity to carry out the investigation. Then there was the issue about, if I capture it right from you, which had to deal with the phenomenon of where you are appearing before your subpoena appeared, your identity exposed, and then your employer decides to. You see, that is why our law provides for a whole part on victimization. That when you think that, you see, the law says, when you think that you're likely to what? To be victimized. Likely. We think that appearing before what they call it, a particular body to say something, there's a likelihood that you'll be victimized. Come to church and lodge your complaint. Look, I did this. I know that what I did, my employer may not take it kindly. So I need protection. And charge you, all right, we'll issue an order to your employer. Say, look, we are aware that so and so has done this. Don't do anything to disturb the person. And the order becomes the order of a high court. So that fear, should not be there at all. I think this is how I want to address your question, that where there are cases of victimization, just come to church. Where you even think that if the victimization hasn't even occurred and it's about to happen, it's like you even, you may be a prophet or it's come on, you come to church, we will take measures to protect you. I think I've addressed the questions, Taraka. Thank you very much.
Oh, yeah.
I think that's a laudable suggestion. You know, already on the continent, we have the African Network of African Human Rights Institutions. You are aware of it. I think that this is a challenge that they can take and ensure that we have a holistic sort of legislation that would protect whistleblowers across the entire continent. Because sometimes some whistleblowers, as I listen to some of the stories, you know, they leave their areas of jurisdiction. They have to go somewhere to seek, refuge. And who knows whether the copies will not follow them there. So they need protection wherever they are. So your point is very valid. It's something that we should consider. Thank you. Yeah.
Thank you so much, Stephen. I think there was just 2 more comments from the floor. There was also another one by Jacqueline Garrick, which reads, how do you assess for psychosocial damages and illness when retaliation has caused emotional or physical harm? It's something to reflect over as well. I am going to allow you, talking from the floor, and then Kyle, you're welcome to come up. Thank you.
I'll just stay because I think I've already asked the question, so the audience knows. Tobile Matanzela again. I think 2 questions from my colleagues from Ghana. I think the first one is, how do you reinvigorate the trust? I think you have noted the political challenges, just the culture of things not getting done. How do you reinvigorate trust? Because I do think as South Africans, we have become despondent, we have become negative, nothing's going to happen. And we have time and again proved that nothing happens. So how do you reinvigorate trust and get people to blow the whistle and come to Shraj? My second question was the Attorney General. And for me, my question is the effectiveness of your Attorney General. You said a whistleblower, once they blow the whistle, where they blow the whistle, they have 7 days to send the report to the Attorney General. A copy of the complaint, yes. 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 Yes, that's what the law says. But how effective is it? Because there is an opportunity there. In my view, if a whistleblower decides to blow to different institutions, within 7 days, maybe 7, depending on when, they would be able to pick up when there's duplication, number 1. Number 2, they could sort of monitor and evaluate the trends, or even connect dots. You might have received a report, but then the Attorney General who receives sort of the whole landscape can then say, but this is sort of related to that, and sort of put the dots together. So my question here is, how effective, or in how far does your Attorney General take the copies of the complaints as well as the reports? Thanks.
Thank you for those presentations. Very insightful indeed. In the interest of time, I'm just going to shorten this. I think the rest we can cover during the closed sessions. But I'll just note it briefly. Mary, I like the point you made about often the case with African countries, but especially South Africa too, when we have a problem, well, what is the solution? Let's create more law. And I think, as most of us have witnessed over the last few years, the effective resolution of illegality, or repeated illegality, is not more law. In South Africa, there's a myriad of laws against corruption. We have the UN Convention, we have the African Union Convention, we even have the SADC Protocol, and those are just conventions that we are signatory to. Then domestically, we have the Prevention and Combating of Corruption Act, and in the procurement space, we have the PFMA and the Treasury regulations. We have the MFMA and the Supply Chain Management regulations. And we even have the Triple PFA and its regulations, which received a second, though tentative, nail in the coffin in Braamfontein last week. But what I wanted to say is the problem is not the absence of law, and the problem is also not that the laws we have are bad. It's the implementation of those laws. And this leads me to the second point that I want to make, because South Africa saw over the Zuma era the progressive destruction of the prosecuting services, and we're only trying to rebuild that now. And I think that's what makes state capture so dangerous, is this private entity or group of firms acts to influence and shape the underlying rules of the game, capturing the state's legislative, executive, and judicial apparatus. And it results, if successful, in a permanent change to the status quo. So my issue then, or my possible issue, which we can hopefully grapple with in the remaining sessions, is with the establishment of an independent anti-corruption agency, because for one, it means another institution or constitutional body, which means more law, further processes, and as a result, increased confusion in respect to the procedures to be followed by the ordinary layman that finds himself in this dilemma. And secondly, what happens when the independent institution that was established primarily with an overarching purpose of protecting human rights in the corruption whistleblower arena is itself captured by a particular set of interests, who incidentally happens to be behind the corporate veil of massive businesses deriving inflated profits from public contracts? And the question then, as Eric Mokonyama rightfully pointed out during lunch, is how do we know who we are protecting ourselves from? So I hope that we can get to that tomorrow. And then just very briefly, Stephen, I want to talk further about the fact that the decisions of the Commission have the force of a High Court order, because I'd be interested to see how that would work in the South African framework, not least with regard to Section 165 of our Constitution, and also the Promotion of Administrative Justice Act. If a decision of the Commission is challenged, is it reviewed or appealed, for example, and all of those things. And then lastly, Mary, the point that you came to add at the end, I really like that, about if someone comes to your commission for protection, gets protection, and then voluntarily discloses to the media, social or otherwise, that they've made this disclosure, and wants to make some grand announcement about their role in saving public money or whatever, I think that might provide part of the answer to the issue of compensating whistleblowers. So the criticism is that you turn whistleblowing into an enterprise, and that there's ulterior motives behind it. People want to become celebrities, so they're using this to do that. And I think if we say that the protection offered by either the Human Rights Commission or the newly established anti-corruption agency that is being spoken about at the moment, or the public protector, if we say that protection terminates upon voluntary disclosure of some or all of the information by the individual to the media or on social media, I think the issue of ulterior motive becomes irrelevant. There will still be some that are doing it just with the financial incentive, but if we recall that it's only a fixed percentage upon successful prosecution, if their information led materially to the successful prosecution, well, then that's fine. We're still going to be saving lots of money, and we will also eliminate the ulterior motive of people doing it to become celebrities in the country. But I think we can grapple with all of this further tomorrow. Thanks again.
Thank you very much. I think some three questions came. The first had to do with what sort of assistance can we as the Commission on Human Rights give to victims who suffer psychologically. As I said, the law says that where a complaint of victimization comes before us, after conducting the inquiry, the Commission is supposed to make any order that, in fact, that's the language of the law. the order that seems to fit. So where we do the inquiry, realize that the person has suffered psychologically, we can make an order directed at government to provide medical assistance, or to make an order directed at the minister for justice to provide medical health for the whistleblower, and they have to comply. So that's one way by which we can do it, apart from other forms of assistance that we may want to give. Then the issue had to do with the reinvigoration of the trust and to get people to blow the whistle. Fortunately in Ghana, I skipped it. We have what we call the National Anti-Corruption Action Plan. The National Anti-Corruption Action Plan is a plan that was formulated by the people of Ghana. I'll use the people of Ghana in quotes because it's a plan that was approved by the Parliament of Ghana. If you look at the way we developed that plan, views were taken from the grassroots. A lot of fora were held with various stakeholders, and all came with ideas as to how we can fight corruption in Ghana. One of the issues definitely is whistleblower protection. So people need to be told that they don't need to fear when they make complaints. They need to know that the Parliament is behind the type of efforts that whistleblowers are making. But most importantly, as I indicate, education and sensitization is very important. And telling certain examples is very important. If, for instance, a disclosure comes before church and we make a decision on an order, and that order is made public, certainly people will see that this is a serious institution, or we have a serious, what they call, institution for protection for whistleblowers. That way, they'll certainly have trust in the system. And we are doing, in fact, some of the investigation that we have carried out as a commission, we don't care who you are. As Mary indicated, even the president can be investigated. And when we are doing it, we do it our full, the whole Ghanaian society is behind us. So we will have to do more education, empower people to get, to develop trust in what we do. And you raise the issue of reporting to the Attorney General. How does the AG take? I don't know if I heard you very well.
Just asking the effectiveness.
The effectiveness.
Once they get the reports, what do they do?
What do they do? So, as I indicated, there are two situations here. The first is that once you receive a disclosure, the law says make a copy of the disclosure within 7 days and send it to the Attorney General. But then the law also says that when you finish your investigations within 60 days, you must send the report to the Attorney General with recommendations for implementation. But as I raise it, whether the Attorney General will do it or not, you have no control. And that's a huge weakness in our law. Of course, if you look at the criminal infrastructure that we have in Ghana, Article 88 of our Constitution says that in terms of prosecutions, it is the Attorney General who has a sole responsibility for prosecuting. So if there's a disclosure of illegality that has been made, and you make a recommendation that the person who has committed the illegality ought to be prosecuted, because what he has done is criminal, the Attorney General has a discretion as to whether he wants to prosecute or not. It's a huge challenge that we have, which we are trying to see how we can. In fact, there are currently going on some reforms to amend even our constitution to separate the powers of the Attorney General from the Minister for Justice. That is something, it's an ongoing debate that is going on. I believe that one day we'll get there. Thank you very much.
I just wanted to check, do you have a monitoring system?
Do you want the mic?
Oh, okay. No, oh, okay. I thought you can hear me. No, sorry.
Yeah, go ahead.
Yes. I didn't. Okay.
All right, here we go. I just wanted to find out, do you have a monitoring system where you are tracking down progress with the Auditor General's office in terms of the implementation? And
I mean, the Attorney General.
The Attorney General,
Yes.
sorry. And then when you see there isn't progress, what's the next step that you take?
Very good question. You know, our commissioners, what they do is that from time to time we have meetings with the Attorney General. But most importantly, I told that we have established what we call a Key Accountability Institutions Forum. The Attorney General is a member of the Key Accountability Institutions Forum. So that's a forum where pressure can be brought on the Attorney General, you know, to take action on investigations that have been done by a sister institution on an act of illegality that has been reported by a whistleblower. Unfortunately, we haven't used it much, but we only established the forum 2 years ago. So we are trying to put the protocols in place, get all of them to come on board. And so we're still in the process. We hope that we'll get there one day, where whistleblower matters don't just lie on the table of the Attorney General and then they die there. We'll get there. Yeah, thank you.
You're done? Thank you so much, Stephen and Mary, and of course all our participants in the room and as well as virtually in the online space. I just want to check finally if we have any further comments coming through. Nothing, and we are now wrapping up. In the wrap up, let me do that. Maybe just to also add that, yes, you may take your seats again. Thank you so much. Thank you. And I want to do a very quick wrap up in terms of the day's proceedings. And of course, I think it's been quite a day and a lot of information that we need to take in, particularly after panel 2, where we heard the experiences from first-hand experiences from whistleblowers. Of course, we started our day around the reflections on the current national legal and institutional framework currently in place. We heard from the Deputy Public Protector, Professor Azumena, who unfortunately also I think had to fly out, and then Professor Richard Calland, who joined us remotely. Panel 2, which I think need not any further explanation, but a lot coming through. We really once again appreciate your boldness and bravery for sharing your experiences, and some who are still, like my sister Patricia, who is very much still embroiled in the saga, and your family as well. And I mean, it's a very chilling, harrowing experience. Definitely shows the need why we need to ensure that there are protection mechanisms in place for whistleblowers. Panel 3, thank you again to Stephen and Mary. Just to also add that one learns from our peers. And as a Human Rights Commission, I found out in passing around the work you were doing with the UN Office on Drugs and Crime, UNODC, where it was the standard operating procedures for whistleblower protection in state institutions or something like that. I take a note of what Ms. Mbeki has also said, because it's that kind of sharing and information that we really need to know. So we know what's happening on the continent and how we can learn from one another. There is the network of African National Human Rights Institutions, which is NANRI. And similarly, there's the Global Alliance of National Human Rights Institutions called GANRI. And those are both mechanisms which certainly can be explored as a way of looking what NHRIs, so Human Rights Commissions, can do, and what best practices and model laws are out there that also fit a particular African dynamic that will work for us, or at least that we can draw on. There was mention also about the establishment of a forum of some sort, or a grouping. There's the Forum of the Institutions Supporting Democracy. They are in attendance. Some of their representatives, that comprises of Chapter 9 and 10 bodies, Public Service Commission and all the Chapter 9ers, some who are now remotely in attendance. So there's that avenue as well, and there's been engagements as well as a conference which they hosted in November last year, looking at corruption and the role of the forum, the ISDs, so the institutions supporting democracy. On the commission side, and Stephen, I was hearing, I mean, it's great to have legislative mechanisms in place. It's beautiful on paper, and like my colleague said, we make laws. We're so good at that. We're so good at running it through the system. My colleague is here from Parliament as well. I mean, we see beautiful laws coming through, but the implementation is the problem. As the Commission, and of course in the sensitization, the advocacy, do people on the ground actually know what that law means? It's written in legalese. They don't understand it. There is certainly, I think, a role for ourselves as the Commission, and then of course the private sector, NGOs. I think it takes a coordinated effort. And on our end, particularly given our mandate that there is this promotion, protection, and the monitoring and assessment or observance element. So whilst we advocate for perhaps legal reform, part of what we're doing today, looking at what should inform a model law, how it should look by the end of, or what elements it should contain, there has to be that protection element that comes with it. And then duly promotion, how does this get shared? To what extent is it the Commission's role to sensitize the public around this? Do they know where to go when they have a complaint, for example? And then similarly, we'd have to monitor and assess. That's all ingrained within our mandate. And then I think those are discussions we can certainly pick up tomorrow. That said, tomorrow there will be closed proceedings. That's day 2 and 3. Some of you I know have indicated your intent to stay and participate in that. And then there will be some colleagues again joining remotely. It's a lot more technical, a lot more of a working group, and we would appreciate more of the, elbow to the wheel kind of engagement, getting a bit greasy tomorrow and talking a lot more frankly. I am going to thank the CEO on my end because he threw me under the bus to let me facilitate. I wasn't expecting this. CEO, I would have made sure that I had a jacket on all day, but it got hot. I'm going to give the floor to you to do the closing remarks or anything else that you wish to add. And then from my end, thank you so much. It has been a very interactive, fruitful engagement. Thank you.
Thank you, Fatla. We knew you'll swim once we threw at the deep end. So it was a very calculated act. Commissioners and colleagues, I'd like to thank everybody. It's been a long day, but a very interesting session and also very informative. And I think there's a lot for us to learn. So I really want to thank everybody and all my colleagues in the Commission for preparing the summit, as well as my principals for allowing us to do this. And again, thanks to colleagues in Treasury for giving us some money to do this. So as Fatla says, tomorrow and Friday will be closed sessions where we'll be working very hard to try and see what we can come up with. Because really what we've been asked to do as the Commission is to look at the legal framework and see what recommendations we can make towards government and relevant authorities to improve the legal framework, as well as what kind of institutional mechanisms we can have to protect the whistleblowers. But we've heard from our colleagues from Ghana, despite their good act from our perspective, there's still a lot of work to do. So we will, as a Commission, continue with this process until there is an amendment and also institutional framework established. Failing which we might have to resort to the courts if necessary. But as it has been highlighted, this is a human rights issue. And we as a Commission cannot sit here and fold our arms and allow human rights violations to happen under our watch. That will be irresponsible, and also that will be against our mandate. So certainly we are committed, and we'll see this journey right to the end. So we'll see you tomorrow then. Have a good day. Thanks. Tomorrow we'll start at 9 o'clock apparently. And then we'll also link with our colleagues who are elsewhere. Yeah, but it's no longer public now, it's only a limited.
Yeah, that's tomorrow.
What time? 9?
9 o'clock.
9 o'clock. We'll try and get copies of the Ghana legislation. I don't know if you have got the bills as well. Can you share those with us as well? Yeah, so we'll give printouts tomorrow for us to have the dialogue. Thank you.
Yeah, we're standing. Yeah, I should say.